Good afternoon, everybody. My name is Kathy Purdy. I'm the marketing supervisor at Von Schoeneck and King. I'd like to welcome you to this week's coronavirus webinar. Just two quick housekeeping items before we get started. For those of you who have not joined us before, please enter your questions in the Q&A box located at the bottom of your screen, and our presenters will do the best they can to address those at the end of the webinar. And please take a moment to complete the brief survey once the webinar has ended. So to kick things off this week, I'm going to turn it over to Pete Jones.
Thank you, Kathy. Good afternoon, everyone. It's good to be with you again. Just give you a brief overview of what we plan on doing today. We're going to start off and talk a little bit about litigation issues and, COVID liability, refreshing our discussion of some of those principles. We will do our weekly feature on, what's going on, an update from Albany. And then we're going to spend some time talking about New York paid sick leave. There's a lot of aspects to this that people are, trying to, integrate. We've got the New York State paid sick leave statute. We've got emergency sick leave, which relates to COVID. And then we've got our Families First Coronavirus Recovery Act. So with that in mind, let's get started. We're going to start off with Steve Ricca. He's in our Buffalo office, and he's going to talk about some of these liability issues. Take it away, Steve.
Thanks, Peter. Hello, everybody. It's no secret we live in a litigious society, and I'm sure that all of you listening and learning as the pandemic evolves have been bracing yourselves for the inevitable. And in fact, although the statistics vary, there have reportedly been thousands of cases filed that are COVID related. Now, these cases aren't all employer-employee health and safety scenarios. The subjects range a wide gamut: paid leave, ADA discrimination, employment termination. But there have been some COVID-related health and safety cases. Again, out of the thousands of reported cases, I think the order of magnitude of the COVID health and safety cases are more in the hundreds, maybe 100 to perhaps 250 cases. I thought it would be useful today to do a quick overview of some of the high-profile health and safety-based lawsuits that have come down the pike since March. I'm talking about, cases against Deep Pockets, Walmart, Safeway, Tyson Foods. These cases are a good illustration of why a written plan is a good investment and how it can help to reduce exposure to lawsuits. But before you think that this is about scaring you, I want to say, at the outset that these are cases that present tough proof problems. So I'll get into that in a little bit more detail, but really the purpose of focusing on these cases is to reassure you that the effort and the time that you're putting into your safety plans and your adherence to those plans is money and time well spent. In some of these cases, plaintiffs are family members arguing that loved ones contracted lethal cases of COVID on the job, and that this is a result of an employer acting either with gross negligence or intentional misconduct. These cases, if you believe the allegations in the complaint, might describe as sort of extreme situations. In other cases, workers who survived the virus are suing for medical bills, future earnings, and other damages. As you can imagine, the early lawsuits are focusing on compliance with federal and state guidelines. Of course, these vary. I think as a general proposition, the OSHA guidelines and standards are less comprehensive, less prescriptive, more lenient, if you will, than certain state requirements. So there's a lot of variables at work here. Again, key points up front. Employers are rarely found liable for employee deaths tied to the workplace. Likewise, in most states, including New York, disallow direct suits against employers and limit remedies to those allowed under workers' compensation. As you know, employers have to carry workers' compensation insurance and pay benefits to workers who suffer a work-related injury or illness. Really adjudicating that question of whether an illness is work-related or a death is work-related presents a complex fact question. Carriers, workers' compensation carriers can contest claims before, in New York State, the Workers' Compensation Board. And ultimately, there will be many opportunities for questioning causation. It's really unclear, however, whether the novelty of this pandemic will change how these workers' compensation and other cases play out. So having a plan will definitely mitigate the risk of being sued. You know, you can sue a cheese sandwich, as they say, but plaintiffs and the cottage industry that's likely to burgeon as a result of this pandemic will be looking for low-hanging fruit, and that's what we want to avoid. So just kind of a quick run through of these cases and the type of examples, what the facts are. Again, taking the allegations at face value. The Safeway case involves a wrongful death suit by surviving dependents of a produce handler at a Safeway distribution center in California. The allegations are that in March, the employee and other workers complained to supervisors about sick workers coming in. Supposedly, management threatened to retaliate against no-show workers. The distribution center, rather than scaling back, expanded hours to meet increased demands. One of the more interesting allegations is that the employer posted a memo recommending against the wearing of masks. Naturally, the plaintiff's lawyers are construing that as intentionally misleading. And generally that the Safeway failed to follow OSHA guidelines by encouraging people to not wear masks. Unfortunately, in April, the employee tested positive and died shortly thereafter. The plaintiffs brought the lawsuit in a state or county court alleging gross negligence and wrongful death, seeking general and punitive damages. Now, in all of these high-profile cases, the defendants, whether it's Safeway or Walmart or Tyson, moved to dismiss, arguing the case is governed by workers' comp and removing the action to federal court, thus shifting the burden to the plaintiffs to make arguments about where jurisdiction should be. In the Walmart situation, there are actions, at least in Chicago and Dallas. In Dallas, there's a wrongful death action pending by the family of a maintenance worker. In late March, the employee reportedly told the manager he had COVID symptoms. The employer allegedly put him back to work, didn't follow CDC or OSHA guidelines, no enforcement of social distancing, no sanitizing, no masks, gloves, etc. The employee's condition allegedly worsened. He told the store management again and was sent home and sadly died 2 days later. So in this case, the family again filed a wrongful death action seeking unspecified damages. Another Walmart action in Dallas involved a surviving worker who argues a failure to provide PPE, failure to take other safety measures. Following some of these initial employee complaints supposedly at the Dallas Walmart, the companies instituted temperature screening, installed sneeze guards, and instituted social distancing, and started to require face masks. Curative measures aren't proof of wrongful acts, but in the context of a health and safety related case and evolving federal and state standards, these are very important circumstances. The surviving employee in the Dallas situation sued for damages in excess of $1 million. Getting to maybe one of the more unfavorable set of facts would be the Tyson Foods situation. We all know that meat processing plants involve numerous workers in close quarters. In the case of Tyson Foods, a wrongful death action is pending by the families of 3 employees ranging in age from 44 to 60 who worked at a processing plant in Waterloo, Iowa. The allegations in that case are that Tyson was aware that the virus was spreading through the plant in early April, that it was urged by local law enforcement and health officials to shut it down. Reportedly, there are over 1,000 positive cases at this particular facility with 5 deaths. The the picture painted by the plaintiffs is that Tyson kept the plant open and was more interested in revenue than health and safety. It's allegedly provided thank you bonuses to employees to stay on the job. Most employees allegedly were not wearing face covers, and safety measures allegedly were not communicated, pointing out, among other things, a language barrier. Clearly, at least on the OSHA level, all of its guidance, I believe, is issued in at least English and Spanish and multiple other languages. So, their resources are available. So Tyson did eventually close the plant. The case is pending. There's, not enough time to sort of cover this in any detail. But in all of these cases, as you can imagine, the defenses that are being preferred by the defendants are that the company took steps to combat the virus, that it, in some cases, screened workers, required the wearing of masks, and really followed the laundry list of CDC and types of requirements you're seeing on the state-specific level. But really, and I think most importantly, or equally importantly, is the employers are arguing that it's impossible to know where or how a worker contracted COVID, which will be and is an interesting question in all of these cases. The burden of proof is high. Plaintiffs need to prove that an employer not only didn't take reasonable precautions, but that the disease was contracted at the work site. So what are the implications of all of this under OSHA and state-specific programs? OSHA guidelines have been evolving since March, since the issuance of the 3990 guidance recommending but not mandating written safety plans. If you go to the OSHA COVID website now, you'll see an incredibly increased level of detail, both generally and on a sector-specific basis. The existing regs governing illness reporting, which are not COVID specific, are potentially useful and relevant here. As you know, you have to report an OSHA illness if an employer determines that a worker's COVID case is confirmed, that it is work-related, and that it meets other criteria like medical treatment, death, days away from work. Here, what occurred to me is, you have this recent revised OSHA enforcement guidance requiring all employers to make workplace-related determinations when it comes to assessing reporting obligations. OSHA specifically recognizes that an exposure can occur both in and out of the workplace, but also provides that you don't need to engage in extensive medical inquiries to make this determination. I guess this is a two-edged sword. It could cut both ways. What OSHA says is, rather than requiring an extensive medical inquiry, you consider reasonably available information. Are there several cases among workers? Tyson comes to mind. Has there been lengthy, close exposure to another worker with a confirmed case? What are the circumstances of the employee outside of the workplace? Are there some reasonably available facts that would indicate the employee was in close contact with sick people outside of the workplace? And of course, input from medical providers. So I'm just suggesting that in the context of sort of mitigating risk and exposure and having a robust plan and adhering to it, when it comes to reporting obligations, you want to be aware of what the state and federal requirements are and make careful determinations in order to avoid any kind of appearance that you're hiding something or jumping to the conclusion that an illness is work-related. Several states, Utah, Michigan, and Illinois, have enacted laws providing presumptions of workplace injury, which I think are intended to alleviate reporting analyses and thought processes. I wonder in those states whether employers are at a disadvantage if there's a presumptive workplace injury that you would then need to rebut. These are all interesting unanswered questions. These cases are pending, but ultimately there are just numerous variables that inform exposure to litigation. State-specific variables, of course. How stringent are your state requirements? We are both burdened and blessed in New York State with very comprehensive requirements for written plans, and adherence to having those plans and adhering to them will definitely be helpful in dissuading lawsuits. The tracing and tracking requirements, for example, in New York State could be implicated. We know, I guess in many, if not most sectors, if not in all businesses, you have to notify state and local health departments immediately if a worker tests positive. You have to cooperate with contact tracing efforts as a matter of state requirements. Notify potential workers or visitors who had close contact, et cetera, et cetera. The list goes on. So really, again, the takeaway here is, have a plan, adhere to the plan, because not only will it protect you from potential exposure, it also reduce the likelihood that you'll have worker illness and loss of revenues resulting from that. So the effects of this pandemic are lasting. They create, new legal threats for employers. The differences among OSHA guidelines and state-specific requirements create some uncertainty. It's not clear whether the novel aspects of this pandemic will change how courts view workers' comp analyses, but employers that act with intentional disregard for health and safety requirements and gross negligence, obviously we would be more at risk. So look at your written plan, adhere to it. Peter, it sounds like you're...
Well, I just was going to try and pull a few things out to get you to comment on. One is, I think you've said that, let's just catalog the areas of exposure, potential exposure. I mean, you could have workers' comp claims, you could have OSHA claims. You mentioned at the beginning, the potential for discrimination claims for people who, allege failure to accommodate or retaliation or, violation of their leave rights. And then I think we could have just sort of negligence claims where people say you didn't act with due care, you owed me a duty. And from an employment perspective, I think, workers' comp exclusivity in New York is certainly going to be the answer to employee exposure claims for the vast majority of claims. So just to put it in that framework, those are the kinds of things that we might see. But for employees in New York, I think workers' comp is really likely to be the primary remedy. But you said something that I think works for all these kinds of claims. The idea that you have a plan, that you follow your plan, that is, I think it answers whether or not you were negligent. I think it generally answers whether or not you're providing a safe workplace under the general duty clause. And it tethers you to defend discrimination, retaliation, accommodation claims because you're following a plan that has flexibility in it.
Exactly. And again, the extent to which a lawsuit may have no merit because of the exclusivity issue is definitely a very important consideration. But we also want to reduce the frequency and incidence of frivolous lawsuits, and that's another sort of a benefit. I had some thoughts on the federal liability protection issue. I don't know if time permits it.
Yeah, just if you can give us a 1-minute summary, and then we'll move to Katie.
Okay, I'll do the best I can. I guess so. In the context of a 1-minute summary, states have been enacting liability protections, and they vary in terms of scope and detail. Clearly, healthcare workers and first responders have been subject to protections in certain states. New York State has made a number of changes via the Emergency Disaster Protection Act. So, by and large, we have a situation where we have a number of emergency declarations, and I think in one instance, possibly Virginia, some legislative action, but nothing comprehensive at the federal level. The news is, rife with references to the coronavirus relief package that's being debated right now. I guess to cut to the chase, I don't see the liability protections that are in the Senate bill being passed anytime soon. This is a bill that would protect schools, businesses, healthcare providers, and nonprofit organizations from liability. unless there's willful misconduct or gross negligence. It would cap on punitive damages, heighten pleading requirements, and the like. The protections would last from December 2019 through 2024. The Democratic-controlled House is clearly resisting this. Labor unions and consumer advocates have been resisting this. And the House, among other things, wants stronger OSHA rules, something that the AFL-CIO unsuccessfully litigated earlier this year. So I think that really time will tell. The election in November will have a significant impact of where things are going. While I think it's doubtful that any federal liability protection will be enacted between now and then, I think that the likelihood of heightened regulation, particularly OSHA regulation under the personal protective equipment standard, will be likely if there's a change in administration. So with that, I'll conclude my remarks.
Thank you, Steve. Let's go to Katie, Katie Anderson in Albany, for a view of what's going on there and what the latest is. Katie, take it away.
All right, it's always busy over here in Albany. First things first, we do have the updated travel advisory. States this came out, an hour ago. We saw Washington State removed, Rhode Island removed, Ohio removed, New Mexico, Alaska, all removed. Added were the Virgin Islands, South Dakota, and Hawaii. So sorry if any of you were at the motorcycle rally in Sturgis, South Dakota. You're gonna probably have to quarantine upon returning to New York. Looking at that, we've had a lot of questions asked. Pennsylvania has been a popular one that people have been asking about, what's going on with Pennsylvania's numbers. Based on what I've seen from Pennsylvania's numbers, they are coming down. They're doing good. It seems like they're clear for another week. So unless something, happens in the next week that really causes some crazy spike, we should be good to go with Pennsylvania. One thing to really look at in New York as well is this week we're seeing colleges start to really go back. And that's going to be something that will likely impact the rates of infection in New York. But the current rate of infection in New York as of today was 0.86. And that's great. That's very low. So hopefully that will continue to hold true. This case, this case came out on Friday. And this case is something that we discussed in June. There was a religious exemption case that came about, and I discussed that in June, and I said this marks the beginning of people using the courts to really chip away at the governor's executive orders. And one thing to note of this is that's true. It's holding true. This case that came out on Friday, it came out of the Northern District of New York, so a federal court. The plaintiffs it was a group of 3 or 4 I think it was 3 restaurants that were also wedding venues. Okay, that component is important. They were, they sued saying that under a host of theories, one of them being the First Amendment, saying religious protection needed to be in place, but also the interesting theory that they sued under was saying that under the 14th Amendment Equal Protection Clause, it was not, they weren't being treated equally to the fact that a wedding would be restricted to having only 50 people at the gathering, but their venues could, under the relevant occupancy guidance for restaurants, could have up to 200 people in that room or outside in the area. They pointed to, the fact that graduation ceremonies could have up to 150 people. So the judge issued a preliminary injunction saying that the gathering restriction of 50 people, it's not supposed to apply to this type of situation. And this is a pretty narrow ruling, but it's, important to look at. this type of gathering being a wedding, but also this situation being wedding venues that are also restaurants, right? You have to be a restaurant or otherwise serve people and be following the restaurant guidance. Now, that's a key component. The judge did not touch any of the reopening guidance requirements. So those venues still need to use social distancing. They still need to require that people be seated in order to have their face coverings off. People can't dance at the weddings, but you could have a room full of 200 people that sit there and eat. I expect, and this is just my personal opinion, that this is likely to be appealed. I don't expect that the state is going to just roll over on this one, especially because when you think about the differences between even the function of a restaurant versus a wedding, you know, even though you go to a restaurant, you sit there for an hour, 2 hours maybe, and you eat, but then you leave. A wedding, you're there for 4, 5 hours in the same place with a bunch of people. So I expect that this will be appealed, but it does signify the beginning of this. It goes along the vein of chipping away at the governor's orders. On August 20th, evidence is going to be presented in a case, class action suit by gym owners that are suing, saying that we should be reopened. I would watch that case closely. They might be using these types of cases to say that there's a good chance that the courts will order that gyms be reopened. But this is going to be more and more common as people grow, you know, more and more angsty with what's happening. Now, you know, one thing too is last week I covered these occupancy updates. So I'm going to do it again because I've gotten a lot of questions since then. I had to do it pretty quickly because we were running out of time. So I'm going to take a little bit more time to go through this. But if you do have any questions, you know, feel free to put it in the chat. I'll be going through the chat after I present. And feel free to reach out directly if I don't get to answer your questions. So remember that in your reopening guidance, it says that you have to follow the maximum occupancy as set by your certificate of occupancy. If your certificate of occupancy has the maximum occupancy on it, congratulations, you're done. You don't have to do any of this. If you are like many of us, where your certificate of occupancy does not list that number, then you're going to have to do this. So the first thing you're going to want to do is figure out the square footage of each area. And that in itself can be hard. You have to figure out if you're in an office building like this, not only do you need the square footage of the entire floor, but you need to be going into the offices. You know, any place that has a door that closes off, you need to figure out the square footage of that office. From there, you have to then figure out what the uniform building and fire codes classification of the area would be. So the easiest way to do this is call your local buildings office or call one of us. It will help you try to figure that out. For many office buildings, you are likely building group B. Okay, so that's just remember building group B. That's likely what a lot of you fall into. Once you have that, you know, it allows you to figure out what your occupant load factor is. So this is just the chart. I will, at the end of this, push to everybody in the chat or in the question and answers a link to an article that we wrote on this last week. It'll take you to a full version of this chart so you can find your relevant occupant load factor once you figure out what your function of the space is. You know, the occupant load factor, that is basically, it's the number of people per square feet, right? It's the amount of how many people can be there per square feet, the allowable floor area in square feet per occupant. So once you have that occupant load factor number, so for business group B, it's 150. In New York State, that's higher than most other states. You know, you can continue on. So once you have that occupant load factor, you divide the square footage of the relevant area, so this office, by the occupant load. So if you had, 10,000 square feet, you divide that by 150, you get to 66 people. I did my office this morning. My office square footage is 175. So you divide that by 150 and you get 1. Once you multiply that number by 50%, or whatever the relevant number is that you have to be restricted by in your based on your reopening guidance published by New York State, that's the relevant number that you have to follow. Now remember, this is required. This is not just a optional thing. If your reopening guidance says that you have to do this, you have to do this. So in my case, my office would be allowed for 0.5 of a person right now. So I'm going to have to figure something out about that, because that was a surprise to me this morning when that happened. So I don't have the answer about what to do in that situation yet, but we're all on this journey together. And with that, Pete, I'm done.
Okay, Katie, thank you. We did some paid sick leave issues last week, and they were frankly of interest to everybody. So we're gonna, dive a little deeper into it this afternoon. I'm gonna start with Andy Bobrek from our Syracuse office, and then Teresa Rusnak from our Rochester office, and they're gonna tag team this issue. Take it away, Andy.
Thanks, Pete. Good to be here. Thanks everyone for attending. I know a lot of you are thinking, yet another new issue, new statute to deal with here. I sympathize. We obviously are doing what we can to reach out to you and provide some background information and guidance. This won't be the end of that. I want you to be assured of that. We'll continue to reach out and talk about this issue. We do have a little time to continue to get our ducks in a row, but now's the time to start planning. So just to give you a quick recap, Teresa did a great job last week of going into the nitty gritty, but there's a lot there. So let's just recap some key things quickly. First, the legislation is set to go into effect on September 30th, but leave is not technically available to the employees until January 1 of 21. But the way to interpret this statute is that, at the very least, if you're going to use the accrual method, those accruals need to start on September 30 when the legislation goes into effect. The benefit that is required to be provided will depend on the size of the employer, and if it's a small employer, the size of its business and the amount specifically of its net income. Here, I think that the key takeaway is the larger the employer, the more leave it has to provide, the smaller, the less. But even with a small employer with 4 or fewer employees and net income of $1 million or less, there still is an obligation to provide leave. It just is unpaid leave. If you review the statute, you'll notice there's a wide range of conditions and circumstances that will trigger eligibility for the new paid sick leave. The way that I would think about it, just so that flag goes up in your mind, is if it's an illness, an injury, or a health condition of an employee, if they require care of some kind for an illness, an injury, or a health condition, or if they have a family member, again, that term is defined broadly under the statute, but if they have a family member who has a need for care for an illness, an injury, or health condition, it will apply. Additionally, if leave is required for a victim of domestic violence, a family offense, a sexual offense, stalking, or human trafficking, those are also triggers for eligibility for leave under the legislation. There is no exclusion for in the legislation itself for part-time or salaried exempt employees. This particular legislation is going to be codified at Section 196B of the New York Labor Law, which is in Article 6. Article 6 contains a very broad definition of employee. It does not exclude exempt employees, generally speaking. And the way that courts have interpreted Article 6 of the New York Labor Law, again, is very broadly, such that unless the particular statute contains an exemption, the requirements apply broadly to all employees. Additionally, as an employer, if you're covered and you have to provide this leave, you can do it in one of two ways. You can either provide it on an accrual basis. So as I work, I accrue leave that I'm then eligible to use. So my bank fills up. The other is to front end load it. And I know we got a lot of questions last time. Well, what do you mean by front end load it? Well, very simply there, as is common in many employer leave policies, when January 1, for example, 21 hits, and you're eligible for 40 hours of paid sick leave, you have that bank of 40 hours of time, and then you can draw down on that amount of time during the course of the ensuing calendar year. So again, hopefully that clarifies that point. If we turn to the next slide, I want to just cover a few more additional points here. Remember, there is a mandatory rollover that has to happen each year of accrued time, but employees are capped at how much they can use in a calendar year. And again, that will depend on the size of your business or organization. We do need to track the accruals and the usage. For usage, we want to be able to show that we provided it when there was a request and an eligible need. And then the accruals we also want to keep track of too. One of the reasons that we want to keep track of those accruals is because employees can request from their employer a summary of how much time they've accrued and have available to date. And it's a fairly quick turnaround time under the statute, 3 days, when we need to respond and provide that information. There's no payout at separation of employment, regardless of the reason, or retirement. That is specifically in the statute there. One cautionary point, many employers have broad leave policies that encapsulate all different kinds of leave, and perhaps intent to have the paid sick leave also be encapsulated in that broad policy. If that's the case, one issue I want to flag is we want to make sure that we're clear in that policy that, hey, any paid sick leave under the New York statute that is accrued but not used, you forfeit that at termination. I still recommend including clear forfeiture language on that point. Again, employees who take paid sick leave are entitled to job restoration. The statute talks about the same job with the same pay and same terms and conditions as before they took leave. And additionally, keep in mind that the statute does contain anti-discrimination, anti-retaliation protections. So again, when you tick through the list, you're coming to a disciplinary action and you tick through the list of things that we want to be mindful of. One of those, of course, is did the employee just recently take paid sick leave? So if we can turn to the next slide, if you haven't started already planning, we wanted to just give you a little bit of a roadmap on what to do here. There's no one size fits all approach. This is just one idea that we have here. Frankly, you could probably mix some of the steps around, but to run through this very quickly, I think you want to first and foremost educate your team. If you're the leader, you want to educate your team on these new requirements and the importance of compliance. If you're part of the team, you want to educate your leadership too. You want that buy-in from them because this is going to be a not insignificant project and processes moving forward. You want to gather your policies up. You want to take a look at those policies, see what type of leave you provide, see what the terms and conditions of that leave is. Additionally, keep in mind, do we have any one-off employment agreements that are out there that might provide different types of leave? Did we put something special in an offer letter because an employee requested that as part of the recruiting process? You're going to fold that in too. I think the third step for me is a key one. This is a statute. We're having to figure out how to draft our policies to comply with that statute. And we're going to be doing this on a broad basis covering all our employees. So we want to make sure that we have our T's crossed and our I's dotted. So work with legal counsel to evaluate your current policy and leave processes to see how they marry up with what's required under the state legislation. As I mentioned, you're going to need to keep to establish a record-keeping process. I think about exempt employees. Yes, we do need to keep track of usage for our exempt employees. Most employers, this is going to be something new, in my experience, that they're going to have to develop and educate on. Finally, you're going to want to train your supervisors, again, about these new statutory requirements and any amendments and changes to our policies. And then finally, push this out to the employees. Having armed our supervisors, again, it's the frontline supervisors who are going to take the questions, arming them with the information that they need to be able to respond and provide accurate information. Just one more step on the next slide I want to mention for those of you who may have a labor organization or collective bargaining unit in place. I inserted on the next slide just step 2.5. There, what you're going to want to do is take a look at your labor contract and do the same type of evaluation. And the question I think you need to ask is, do we need to do anything else beyond what we have in the labor contract? The statute does provide some guidance. It could be clear in my view, but it provides some guidance that we can work from. And it could be as simple as having a quick conversation with the union. But what you're going to want to do in that situation is work with your attorney, take a look at the labor contract, take a look at your leave provisions. You need to evaluate the relationship with the union, and then put forth a plan of action on how to address this. Keeping in mind, we have separate potential obligations under the contract as a matter of contract law and under the National Labor Relations Act. All right, finally, before I turn it over to Teresa, I wanted to just mention a few FAQs on the next slide. These are questions. I have to give you credit. I read the questions in the Q&A, every presentation that we do, and you come up with great questions. You got all the hard ones every time. So kudos to you and being keen to these issues. These are questions that we have too in many instances. This legislation, like so many that we've dealt with to this point, was hastily drafted. It does not fill in gaps that are evident from plain reading of it. And thus it entails some decision making and some judgment to exercise. And so you'll hear me say, well, this is something you need to assess on an individualized basis. And that's not passing the buck. That's the advice that we're going to give you, because the individual facts and circumstances and the business judgment of the organization or business is going to matter in making those decisions. But one question we get a lot, well, hey, it says I need to provide 56 hours of time. I've got over 200 employees, but we have a paid time off policy that provides 72 hours at a minimum to employees. Is there anything else that I need to do at this point in terms of providing additional leave? Here you can read the statute, at least the intent of the statute, as I'll elaborate in a little bit, for the proposition that, well, if I give 72 hours of time and people can use it for whatever reason they may want, including the enumerated reasons under the new legislation, that's enough, right? I would say we'd like the language to be a little clearer and the intent to be clearer in the legislation than it is, but we think that's a fairly reasonable reading of the legislation. And I say that because this legislation was modeled after a similar ordinance that's in place in New York City that provides paid sick leave. And that legislation provided and has been interpreted to reach just that point. So if I provide that 72 hours, that's enough, as long as employees can use that for the enumerated reasons under this. But keep in mind, we also have to make sure that that policy has the proper accrual, or it's front-end loaded, that it contains the necessary minimum usages. Again, it can't be anything more than 4 hours at a time. We can set a minimum use, but it can't be any more than 4 hours at a time. And we have to make sure we're dealing with the accrual, the rollover of time, in a manner that's consistent with the legislation. I already answered about tracking exempt employees. We need to do that. Casual or temporary workers, again, it's a broad definition of employee. The New York City legislation did contain an exemption. I think it was employees who work less than 80 hours a year. The New York State legislation doesn't have anything in that expressly. Maybe we'll see something for guidance, but if they're your employee, like you issue them a W-2 statement, they are going to be covered. How much time that you may need to provide a part-time employee is another unsettled issue. We've been working with a number of clients on this. We've got several different approaches that can be used to apply and interpret this. Again, work with your attorney here at Bond on those issues. Student workers is another question I've gotten at colleges and universities. For student workers, again, if they are employees, there's no exemption in the legislation for student workers. Now, there was enumerated exemptions in the New York City legislation, again, which served as the model for this, but nothing in the actual legislation. I think that's something you're going to need to evaluate on a case-by-case basis. One method that we'll use from time to time is looking at this and saying, all right, well, is their relationship with us principally academic in nature, or is it economic? Again, that's a legal analysis, but that's one tool that we could use that's really a creature of the FLSA to try to evaluate, okay, do we need to provide this type of leave to student employees? How do I count the number of employees to determine, hey, where am I at? Am I under 100, over 100? The statute really just says if you employ over 100 in a calendar year, that's it. There's no additional guidance. It's not, do you average? What if I go up? What if I go below? Again, you're going to need to assess that on a case-by-case basis. But I think one reading, fairly fair reading, is to say, hey, if I bump up, certainly if I bump up over that threshold during a given year, well, moving forward, as I stay above that threshold, my employees are provided leave under the legislation. And I think one of the bigger questions we've got is, hey, when are we going to see some guidance from the state on this? Obviously, this isn't directly related to COVID. Again, the emergency sick leave is separate. That deals with COVID and quarantines, and leave that are provided to an employee is subject to a governmental quarantine or isolation order. But when are we going to see something on this? I'll commit to you that we'll make further inquiries and try to get some insight. Nothing is out yet that I'm aware of. I checked again this morning. I've been monitoring the state register to see if there's been any regulations proposed. But under the legislation, there was supposed to be a broad outreach and communication to employees about this. We haven't seen anything. We haven't seen any guidance. Hopefully, if and when we do, it'll fill in some of these gaps that I've talked about today. All right, Pete. Sorry, I ran a little bit longer there than expected.
That's okay. Just real quick on that last point. I mean, I think we have historically seen, a lot of these guidances issued kind of at the last minute. I know this is on everybody's mind. It's a question that I've had from a lot of different people. But I'm just a little bit pessimistic that we're going to get a lot of advance notice on the guidance, especially given, all the other pressing issues that the state is, dealing with the COVID crisis. So,
yeah, Pete. The other question I've gotten is, do you think they'll delay implementation of or suspend the legislation? I haven't seen anything. I reached out to Katie last week as she's tracking these things very closely. I don't want to speak for her, but Katie hadn't heard anything along those lines when we talked. I haven't seen that. I would frankly be surprised, just because this has been an initiative that Albany and the governor's office has been after for preceding COVID. And again, I'm skeptical we'll see somebody step in and suspend it, but as soon as we hear something, we'll let you know.
All right, let's go to Teresa. Stay with us here. I think it'll be worth your time to spend a few more minutes and hear Teresa's update. Really a paid sick leave, paid leave part 2 here.
Right. So while Andy addressed the federal side of things, Pete addressed the state side of things, I'm going to look to the federal, and I'm going to talk primarily about that court decision that, if you joined us last week, Jessica also discussed. This was a decision that was released last week in the Southern District of New York. A federal court ended up striking down large portions of the Families First Coronavirus Response Act, or the FFCRA, as we've been known to call it. So, as Jessica mentioned, for those of you that joined us last week, there are a number of things that have changed in the wake of this decision, and a number of things that I think employers need to be aware of. If particularly you are granting leave or have denied leave or have touched on any of the conditions that were struck down by the court, that's something I'd encourage you to reach out to your attorney about and to seriously consider what risks and rewards are at play in wake of this court decision. So just as a reminder, there were 4 things that the court looked at when it came to the FFCRA. The first thing was the so-called work availability requirement. Under the original Department of Labor guidance, they had said that if the employer does not have work available for the employee is not entitled to leave under the FFCRA. The court looked at that requirement and struck it down. The court did not replace it with anything. The court did not tell DOL what to do. They just looked at that requirement and said that that was not a valid one. So it's just something to flag for you there. Another thing that the court looked at was the documentation requirements. As you know, DOL had issued guidance saying that you can get a certain amount of information from your employees in the form of documentation before you allow them to take EPSL or EFMLA. The Department of Labor had, said that was related to the tax credits, and employers were allowed to collect that kind of information. The court looked at that and struck that down and said that that could not be a condition to allowing the employees to get the leave, either the EPSL or EFMLA. That's not to say that employers can't request documentation or require it in some other form. They just said it can't be a condition precedent to getting the leave. Another thing that the court looked at was the intermittent leave issue. As you know, for employees who are out on leave or who want to take leave to care for a child whose school or child care provider has been rendered unavailable due to COVID-19, be it closed or otherwise, then they can take intermittent leave under the FFCRA. Initially, Department of Labor had said in its guidance that that intermittent leave can only be taken with the consent of both the employer and the employee. When the court looked at that rule, it struck it down and it said you no longer need the consent of the employer. It can be on the employee's own initiative. And then finally, and I think this was arguably the most significant portion of the decision, although certainly as a whole it is significant, the court looked at the definition of healthcare provider. As you know, or as many of you know, healthcare providers and healthcare employees were one of the broadest exceptions under the FFCRA as it was originally published and interpreted. The court looked at the definition of healthcare provider that the Department of Labor set forth and said it was too broad, and it narrowed the definition back to the actual individual employees and kind of took it away on a broader scope. So they did not give us, unfortunately, a new definition of healthcare provider, so we're a bit stuck in limbo on that one as well. All of that is to say, if you are a healthcare provider, or if you have healthcare related employees, or if you're making employees ask for your consent before you give them intermittent leave, or you're not giving employees leave under the FFCRA because you don't have work available, or if you're requiring documentation before giving leave, if any of those four things have applied to you or are applying to you, it is a good idea to reach out to counsel and kind of weigh the risks and benefits to each approach. We do not have all the answers on this case. We don't have many answers on this case. Last we heard from the Department of Labor, they were considering their own options, whether they were going to issue new guidance, whether they were going to appeal the decision, or what exactly they were going to do. Please stay tuned. We'll certainly update you on that as it becomes available. Until then, again, I encourage you to reach out to your attorney and kind of get a sense of what the risks and consequences could be with any particular course of action. And with that, I'll turn it back over to you, Pete.
Thanks, Teresa. One of the things that I guess we've touched on a little bit, just to wrap up several themes here, is that, a lot of these actions at both the state and federal level were taken pretty quickly. And even the FAQs and the guidance that came out from the DOL, that, was, a matter of weeks after the legislation as opposed to immediately. Subject to challenge here and subject to, people thinking about it and saying this doesn't fit or that doesn't fit. So we're now seeing that. And one of the interesting questions that Katie had raised is, will these decisions be appealed, and what will be the impact in the interim, certainly, and perhaps in the long term, on if these provisions are invalid, with respect to the limitations on wedding size, or with respect to the, the conditions of leave under the FFCRA, what is that going to mean for businesses, for employers, and for employees? So we'll keep on it. We'll keep you posted. We'll give you the latest information as it develops here. I want to thank everyone for sticking with us today and for attending as always. And we'll talk to you next week. Stay safe.